Preservation protocols. These are the two protocols that you can use internally to help manage your client's situation. Data management plans and litigation hold programs. This is the safe harbor under our new state court rules, or relatively new state court rules, that you can utilize to your advantage. So what are they? Data management plan. It's a plan that you create with your own client. You want to build it on your client's own IT architecture, meaning you have to ask them how they're using technology, what they're using, and then you build a little plan around it. What is the plan? The plan is, are they going to store everything and keep everything? Maybe not. Maybe that's not necessary. Maybe they're going to delete things every 6 months or every 12 months. That's what your plan is going to be about. That's what it's going to state. So when they comply with the plan, they're under the safe harbor of Rule 1.280. And of course, the purpose is taking advantage of that safe harbor. Litigation holds. When does it arise? What has to be held? No, it has to be held. I'm sorry, spoliation and the risks. The obligation to preserve data is different between federal and state court. In federal, it's much earlier. It's when there's a reasonable expectation of litigation. In state court, it's not until the person gets served with the lawsuit. But you can use a litigation hold notice to advance that in time in Florida state court. When you know that you've got a dispute and you know that there might be a suit coming, you can send out proactively the litigation hold notice and advance that obligation to preserve data earlier in time. Does anybody know where in our rules of procedure you can find the sample litigation hold notice? Crickets. No answer. That's right, there is none. The group of 6 people that worked on the amendment to the rules grappled with this. They tried to come up with a sample or standard litigation hold notice, and they couldn't do it, so they abandoned it because there is no perfect way to do it. What you need to focus on in your litigation hold notice is giving enough information to the other side so that they'll know what it is that you want them to do. And then leave it open and say, if you don't understand or there's a problem, contact me. Now, I have put on the Everything eDiscovery website under the Members tab, there is a sample spoliation/litigation hold letter that you can utilize and borrow from. This is a little standalone piece of software called Legal Hold Pro. And I mentioned earlier this morning that occasionally I would bring these things out. This is just to tell you that things like this exist that you might not even be aware of. This is specifically designed to create legal holds for your client. You draft the legal hold, it goes out like an email, and it gives you this response where specific people in a business have to take certain actions to respond. And it'll come back in this particular software as red and green, telling you if they've done it or they haven't done it. It's basically a tracking mechanism for litigation hold. You could make one on your own, but there is software out there that does exist like this that you can use. And that's what it looks like in their particular software, this Legal Hold Pro, where it gives you that report back.
Is that potentially a bad thing? To be sending that out within your own client's company, potentially based upon the negative results that you might get?
The question is that potentially a bad thing? If you send a litigation hold notice to your own client, to various employees, if there's enough employees, is that a bad thing? Never. There are only a few certainties in law where things are so crystal clear that you absolutely can say 100% guaranteed this is how they are. And when I say it, it's guaranteed. I think it's a case-by-case basis, to be honest with you. I don't see how you could perceive of a situation where sending out a legal hold notice to your own client would be negative, because generally speaking, this process, this litigation hold that's internal between you and your client, is going to be protected and privileged. There are only some rare cases where there has been production required of the actual legal hold notice and the results and things. Generally speaking, this is private between you and your client. It's protecting you and it's protecting them, and it's just a tracking method. If you just told them, preserve this certain stuff, you're really not meeting your duties and responsibilities and obligations because you don't know if they've actually done it. This type of software or anything you would make, even if you just use an Excel spreadsheet, that would give you the ability to track it. So if it comes up later and you're challenged about it, you have a mechanism to show that you took certain actions and you tracked it. Does that answer your question?
Yes, but only to the extent that you follow through after getting the negative information. If you're going to do nothing after finding out the negative information, then it could be a problem.
Yes, yeah, and the comment there for the benefit of the video is only to the extent that you would follow through. If you didn't follow through, if they didn't comply with your hold and you do nothing about it, yes, then you've got a problem. So you still have to do it. You still have to follow up on that. You're absolutely right. Cicada, our sponsor for today, has this very interesting Firmata legal hold software. It's not built into the eDiscovery software. It's a side-by-side software. But if you talk to Connie and at one of the breaks or at the cocktail reception tonight and you're really nice to her, she'll give it to you for free. Or if you say that you're at the CLE, I'm sure that she'll give it to you for free. Just tell her that I told you it's free. You'll be good to go. This is what it looks like, and you can see the similarities. This is just blue and red. The other one was green and red. It's just giving you the ability to manage and conduct this litigation hold with your client and track it and protect yourself and your client. But just like Mr. Rabin commented before, if you do nothing with the negative information, if your client doesn't comply, that's not helpful. But it gives you the ability to more easily track it, and that's built right alongside. It's not built into it. It's alongside. It's an add-on to their software. So that takes us into the collection arena. So when you're planning for collection, you're talking about collecting the data from your own client, either before or when you get a discovery request. You're going to go out and kind of amass this stuff from your client. You're going to do a custodian interview, and the document location questionnaire is available for you to use on the Members tab at Everything eDiscovery. You can modify it however you like, but it's a baseline for you to utilize. The real question sometimes is, do you do it on the phone or do you actually go to your client's office? And this is where your own experience and judgment is going to come in, because you may find that going to the client's office and talking to them about how they keep their data and what they have might be helpful, because while you're sitting in the client's office talking to them, they turn around and they start using a tablet. Now, they've told you that they have a server or they're in the cloud and they have computers. They're not thinking that there's this other data sitting on the tablet. And you go, whoa, wait a minute. What about the tablet? Hey, does everybody have one of those? Oh, yeah, we give them out to all the employees. They've all got it. Aha. Now you've hit upon another area that you can say, do we need to start looking at collection from tablets or phones? What happens to these things when the employee leaves with the bring your own device policy, or they've given them the tablet, that type of stuff. And that's where a company like eDiscovery Services, which is out of Miami, there are not many of them around. There really aren't any in Palm Beach County particular that do it. There are a few dotted around the state, but Juan has been kind enough to send his slides and his audio. So I'm going to play these slides and the audio for you. What they do, as I said earlier in the introduction, is they basically connect up to these devices and draw that data out of it for you. So this is a good third party to know is out there if you need them and you need to rely upon them.
I want to thank David for allowing me to present today on computer forensics. My name is Juan Peralta. I am the owner-operator of eDiscovery Services. I'm a Florida registered paralegal with 15 years of experience in litigation support. For the last 3 years, I've added computer forensics to the services that I provide clients because the vast amount of data that one needs to collect from handheld devices, computers, servers, laptops, anything that contains storage media, in order to completely gather all of the evidence or data to analyze in preparations for trial. Perfect example is the Deflategate scandal involving Tom Brady, where he didn't produce his cell phone for inspection. He destroyed it, and the NFL suspended him for 4 days because he didn't allow inspection. This next slide is between the two equipment managers. where one is calling himself the deflator in exchange for him providing deflated balls in exchange for memorabilia vibrating. Another famous example from the same area, or the same team rather, is the murder of Aaron Hernandez, where Aaron Hernandez texted Andrew Lloyd to get him to come out for the evening, and took him to an abandoned warehouse district and ultimately killed Lloyd. This is the actual text message from Hernandez to Lloyd, asking him to come out on that night. Besides the obvious contents of the mobile device or laptop, what is not there can also be used. Forensic examination allows you to prove or disprove that certain acts were committed contrary to statements made by parties. Analysis of forensic data proves or disproves allegations in the complaint. When was the computer, phone, or tablet last accessed can be verified by checking the registry files. Who accessed the computer and what time, and how many times did a particular person access the computer. These are all things that, if statements are not in line with what is found in the information from the computer, can prove or disprove the allegations in the complaint. To do the actual analysis and reporting of the data collected, eDiscovery Services uses the Access Data suite of products. We use Forensic Toolkit for the forensic examination of the computer and hard drives, Mobile Phone Examiner when collecting data from mobile phones and tablets, Password Recovery Toolkit is our password cracking utility when attempting to crack passwords. Now, FTK and AD Summation, or hosted review platform, is interoperable, which means that they use the same SQL database when accessing that data, which means it's a stronger chain of custody when presenting that data, because the data gets handled only once and both softwares have access to it, thereby eliminating chances of mishandling of the data. Now that the legal hold has gone out and received, key points for a forensic investigation. We need to collect key dates and events for a timeline to seek data out from the data collected. Key pieces of information to be collected, such as internet chats, internet history, emails, deleted files, or any of the data that may be that needs to be harvested from those devices in order to prove the case, such as a key terms list for data carving. We can use a key terms list to run it across the deleted data or files to see if any of those key terms exist in the files that were once in active data. What we also need from the clients is physical access to the machine. We need access to the computer, server, whatever handheld device is that we're going to be imaging. Any passwords that we require to access that device. If we don't have a password specifically, if it's an iPhone and you don't have a password, we cannot do anything with the device because of encryption methods deployed by Apple. If the computers are encrypted or require decryption password keys, we need those as well. And a list of any custodians that we're going to be collecting and any data shares that these custodians have access to by way of a data map. A data map is basically a chart or a drawing that lays out where the data resides, such as a server, a laptop, a custodian, meaning do they have a cell phone, do they have a tablet that they may use, is it personal, is it company assigned, any relevant information as to how the data is handled within the organization. Please call us with any questions that you may have. We're here to help. Or you can visit us at our webpage, eDiscoveryServices.net. There is a contact us form there that will reach me immediately. We're available 24/7. Please do not hesitate to call on us. Thank you and have a good evening.
Unfortunately, Juan had to leave the country as a result of some entanglements with the authorities. He's on the lam, as they say. No. He had a actual work emergency where something came up with forensic collections, so it was very kind of him, even though he couldn't be here, to give us that information. And really the takeaway in what he was talking about a moment ago about what they need is access to the machines, the passwords. That's giving you sort of the secret sauce, the secret recipe, if you will, for what you need to put into your request. So if you know you've got mobile devices, the start point is to call them up and say, this is what we're dealing with. What can you do? How much does it cost? What do you need? And people like this that do it all the time will guide you and help you to form the discovery request that you're looking for. That's going to bring us into the next arena of processing. And I'm going to give you just about a 30-second break here so we can stay on target and meet lunch, if that's all right. Okay, I'm going to bring you back into the processing, review, and analysis segment here of eDiscovery. This is where eDiscovery software itself comes into play. This is actually the use of eDiscovery software. And eDiscovery software, particularly that you're going to see this afternoon, is extremely powerful and fast in the way that it can search through data. Okay, there are some basic eDiscovery definitions for you on the website, just to give you the vocabulary of these terms and some additional sources of information. And again, that's your password. This is just a small snapshot of the very many eDiscovery software providers that operate in this market space. There are about 900 plus out there. Some of them are resellers of other software. They've taken original software and layered their own stuff on top of it. Others, like Cicada, are an original vendor. They've created their own search engine, their own algorithm in that software. So how do you find, with all these options out there, how do you really find the right one if you're looking out there, what's going to be the best one for your particular case? So where do you go to actually evaluate the various options out there and to see what's available? eDiscovery Software Reviews.com. It is a Consumer Reports type review website that everything eDiscovery created for you, so that you can evaluate the software and determine what's the best for your particular case. There's nothing that says you have to use the same software on every case. Once you get the hang of this stuff, it's going to be easy. It'll be like switching from one web browser or one type of program, because it's all kind of very similar in a way. But this will give you the options. Certain software might be better for different cases, and you can talk to these vendors, narrow it down, and then you insulate yourself because you're vetting these vendors of which one is best for your case. What do you want in the software? What are some things that you want to look for that they're going to give you? You are their customer. So what do you want to get from them? These are some of the things that you want to get. All of them are going to say they're fast. All of them are going to say that they've got reduced upload and storage charges and things like that, because there is a ton of competition. 900 plus vendors. It's a consumer's market. You can contact these folks and say, look, this is what I've got. What deal can you give me? And you can work with them, and they'll work with you. They have to, because you are their customer. There is a vendor interview questionnaire that I put on the website for you that, again, easy checklists. You can go down that checklist when you talk to the eDiscovery software company and ask them those particular questions, or record the responses and the information, which will later give you the ability to, in some manner of speaking, try to compare apples to apples and help you out in that regard. So, the costs. Technically speaking, the costs come in a lot earlier than we're dealing with them now. The costs are usually the first thing that you and your client are going to look at. But if we put this right up front and we started talking about it this morning, there would be no frame of reference. This would be completely out of order. But this is actually, in your case, this is happening much early on than just going to the software vendor. So how do you estimate it? When do you start discussing? Just like voting, early and often. I got some laughs. I got a couple. I know it's getting close to lunch. We're going to get you there. So what are some of the cost components you're going to look for? This is the stuff. These are the factors that are going to lead to the costs that your client ultimately has to pay, which is a recoverable cost in the case that you want to track. And if you look on the bottom, cloud9 eDiscovery.com, that's a great website. At the very end, I'm going to give you a whole list of websites, and there's a handout on the Everything eDiscovery website with the references for you. But there's a lot of information out there online in the open for you to find. Some of these websites, like Cloud9, they've got a weekly email digest. Some of the software vendors, you can sign up for free. They'll send you a weekly email digest of all kinds of cases and things, and it gets to be a lot of all that information that's happening out there. This happens to be a little cost calculator that is available online for free. You just plug in the information, and it spits out the total cost. You could do this right up front in the case. When you're doing early case assessment, if you have an idea of the volume of data, and you know who's going to review it, and you know their hourly rate, those are all the factors that go into it, you can actually come up with something of a budget for eDiscovery that you can then sit down and discuss with your client. And like the example I gave you earlier, where the attorney had the client who was defending the case, and the cost of eDiscovery wound up being enormous, had they undertaken this effort early on, they would have been in a better position because they could have analyzed the information, and then that attorney would have been the hero for the client because they probably would have avoided a lot of fees and costs in the suit. Interestingly, Cicada is the only eDiscovery software company out there in the marketplace, as far as I have been able to determine, that has a cost calculator built into its software. This is extremely helpful for you because if you're using it in a case, the data set, that big virtual stack of documents that you got from your client, is already uploaded to Cicada and residing in its server, so it does half the work for you because it's already telling you how much data you have in that little rainbow at the top, and what you're going to fill in is here on the bottom right in the cost profile, the reviewer, the cost, the number of reviewers that you have, and it gives you a budget for it. This, interestingly enough, actually came out in response to a client of Cicada saying, we need a budget for this stuff. So Cicada, reacting to the market forces, went back and said, why don't we just build it into the software? And there you go. And that's how this stuff develops, and develops quickly. So we're talking about a different leveled approach. You don't have to do it this way, but here are some options. You could compress this together. It depends how many people you've got, but you want to do your search. You want to look back and assess it, and the whole purpose of why you're doing this is to make your production set. It's basically the digital equivalent of what we all used to do with the big stack of documents and the bait stamper. It's now just happening virtually, and it's happening in a web-based environment in the eDiscovery software, but that ultimately, to simplify it, is what's happening. So how do we do this? Well, first we want to take a step back and sort of see the forest for the trees. Again, using that kind of early case assessment mentality. We want to look at what we have before we start diving in and starting to search for things. You can do different levels of review. If you're a solo, this is not really going to work. If you're in a very large firm and you've got a whole bunch of people at your disposal, it may. But if you're a solo and you've got co-counsel on the case, this software allows you to share the searching, share the data, share results, send messages back and forth. So it's almost like having an extended family, if you will, that's doing all this searching. Keyword searching is the most common. There is, as I mentioned before, technology-assisted review. But in my view, you wind up having to have so much data that you haven't a clue at what is in this data set. And then you're already in trouble. So more often than not, in the garden variety case that we're all going to see, we're going to have an idea of what this data set contains because we're limiting it by the custodians, by their email addresses. Person A sends something to person B. They communicated with person C. Do we have to go look for people X, Y, and Z? No, they're not part of it. We're just looking for A, B, and C. Date ranges. If there was a contract, to use that example again, that's in dispute, and the contract was negotiated, it went into operation, then it was breached, and that goes back 18 months. Do you have to start searching for 10 years of data? No, it's pointless. There's nothing that's going to be in that data. You don't have to look that far back. So you've already got kind of collars on your data. You've got the custodians. You've got the date ranges. You might even have some keywords and things that you're carving out. So you have this smaller chunk of data. You don't just have all the client's data. So you start looking at keywords and you kind of test them. And we're going to do this later this afternoon. I'm going to show you what happens when you test out the keywords and you're sort of looking in the data set, and it really makes it much more, it brings it down. If you have 10,000 documents and you start putting in these search terms, it reduces it down and now you've got 50. Who here wants to look through 10,000 pages?
Only if I'm being paid by the hour.
Yeah, only if you're being paid by the hour. That's why I have my hand up. It's mind-numbing. Anybody remember the old days of searching through all the banker's boxes of documents? You don't have to do it anymore. And you're providing a more effective and efficient service to your clients doing it this way. The privilege review. You don't want to be sending out privileged stuff. But when you talk to your client, you're going to say, did you talk to any attorneys before me? If so, what were their names? What were their email addresses? Because you can put that stuff in and segregate it out of the data set. So you're not accidentally producing any of that stuff. And the most important thing that comes up, communication with the client during the process. You're going to be looking through documents, you're going to find stuff, and lo and behold, there's going to be somebody copy it on an email. Barbara Smith. Huh. Who's that? You call the client. Oh, that's that lawyer. I totally forgot about her. That's the lawyer that I talked to who was going to draft part of it, and we had a couple of counseling sessions and this and that. Aha, okay. Now we have some privileged material that if you hadn't talked to the client, there could have been inadvertent production. The other side can say, okay, now it's waived. Now we want to go get more information, yada, yada, yada. And again, this is Cicada's own cost calculator that's built into their analytics, which is extraordinarily helpful. I'm going to demonstrate this for you this afternoon, but it's extraordinarily unique and helpful when you're working on this stuff with your client. And you can wind up, again, being the hero because you're telling your client, if we had to print all this stuff out and I have to look through it or subcontract out people to come in and look through it, it's going to cost thousands of dollars. Guess what? With the press of the button, I can save you those thousands of dollars. Now they're your client for life. It's a service industry that we're in, and you're providing the best possible service, and that's what they want. That's what they're looking for. Some unique areas or hot topics in eDiscovery overall when we're talking about collection and forensic collection, text messages, not easy to collect. That's why you've got to turn to the experts. You've got to turn to somebody like Juan Peralta. The reason why I stress him is he is a Florida registered paralegal. How many Florida registered paralegals do we have in the room? A lot. It takes a lot to get your registration. He knows things. Being a Florida registered paralegal, he understands chains of custody. He understands the rules of evidence. He's not a lawyer, but he doesn't have to be. He's smart enough to understand how to get this stuff, do it right, and preserve it so that you can call him to testify. So that's the person that you want to lean on when you're trying to get text messages and figure out if it's even possible to do it. Social media, big in the personal injury arena. How do you get, who can tell me for a Starbucks gift card, who can tell me how you collect social media? Oh, wait. Subpoena Facebook? Good luck with that. No, we don't know. We're lawyers and paralegals. We're not IT people. Yeah, right. You fake friend them. Right. You fake friend them. Exactly. Now, what you do is you pick up the phone. Right, Starbucks. Yeah, here. Sorry. What you do is you pick up the phone and you call Connie at Cicada. and you say, here's the situation that I have, early case assessment. Can you help me? They're the industry experts. They're the ones that would guide you and say, yes, no, here's what we can do, here's what we want, here's how you structure the request. Or you reach out to friends. You call up Michael Pike. In fact, who's got their phone? Let's call him right now. He's on his way to Miami. He's in the car. You call him and you say, hey, I heard that you dealt with this type of a situation in a case. What did you do? How did you do it? That's how things happen. You call other people at other firms and you get the information and it builds on itself. Next, I want to bring up Chioma Deer, who is a deer, by the way. She is going to tell you how to effectively manage eDiscovery projects. Chioma is a certified eDiscovery project manager, which she's going to explain to you very briefly.
My experience with electronic discovery has really been as a litigator and as a project manager. So I try cases, I move things along, but I've also been known as the discovery queen. I'm the one that drafts the discovery, gets the discovery, and use it to move the case forward. I'm also have been listed as a special magistrate with the 15th Circuit, as well as I am available for consultations to do electronic discovery to help your case depending on what you have going on. So as far as what's an eDiscovery project manager, project management is, it might seem like an amorphous thing, but it's really what attorneys, paralegals, and vendors do. If you have a case, it's a project. You know, we're not all Six Sigma black belt kind of people, but that's really what you're doing. You're managing information, you're managing people, and you're moving things forward. But at this point in the game, what we're dealing with is, what do we do when we get discovery? What do we do when we ask for discovery and get something that, one, we wanted to get just because we were trying to get them to give us ESI, or we asked for discovery and inadvertently got ESI and don't know what to do with it now. So at this point in the game, you're looking at how to manage this project in a discovery form, not just the entire case. So you want to use electronic discovery and technology to get the information to move that case forward. The one thing that I always think about when I'm dealing with project management on the ESI level is a checklist manifesto. I don't know if anyone has read that book, but it's a really good book to use to get your mind in that way of thinking, that you have to go through a series of steps, just like looking up the rules of civil procedure before you do something, in order to make sure that what you're doing is cost effective. But project management isn't a tool. It's an organizational method of a framework geared towards effectiveness, efficiency, quality, cost, and risk containment. You want to make sure that you're not wasting your client's money. You want to make sure you're not wasting your money with what you have to do. So as far as dealing with ESI, what you've already heard is about knowing the case that you have, but also making sure that you understand where you are in EDRM and then using the technology that you have to move it forward. So that's where we are with project management. Is it moving? Okay. So the standards that I have included as a handout for everyone to use, or just really as a starting point, it can be applied to a lot of the different areas of the EDRM. We picked the processing, review, and analysis portion because that's really when you have to figure out how you're going to attack this and how you're going to apply it to your case. Then these are some of the things that I include as far as what you want to do to make sure that your standards or your standard operating procedure for addressing electronic discovery and ESI when it comes through your door or when you're sending it out, that it goes into these processes, that you make sure that you do it this way, but you also keep it simple. Simple is safer. if you can understand it, you can also then explain it to your client, and also explain to your client the basis for the cost of doing things the way that you are doing it. And project management principles are ideally suited for the management of electronic discovery projects because it helps to include the processes as well as the task, but keep them standardized so that you're going to have a repeatable thing, not only for each electronic discovery request or production that you're doing, but also to be able to can explain it to the court and your clients. So the standard document will include instructions, or could include instructions, flow charts. You want to make sure you know where your data is going to be when you get it. But you also want to make sure that you have bait stamps assigned. Some people will have discovery coming in and you bait stamp one thing going out, but you don't bait stamp the next request going out. Or you get documents in that may be bait stamped or identified, but you don't keep track of them that way. That's some of the things that standard procedures with discovery would help. And the other thing I wanted to mention is the attorney is ultimately responsible for whatever is going out the door. So you want to make sure that if you're the paralegal, if you're the attorney that's handling this matter, that you know you've gone down that list, and when the attorney who is responsible for it going out the door, they'll see that you have already accomplished everything that's on the list. So my little chart or document that I have attached with this program today has 5 simple areas that I believe need to be included in whatever standard or process that you're using for electronic discovery. Reviewing the case details, confirming the collection, familiarize yourself with the review tool, review the analysis protocol, and then confirm the production plan. A lot of that is for documents going out, but it also includes documents coming in, because when you get documents, you're also going to be using them for depositions, to prepare other discovery that you want them to send to you, and also to prepare for trial or hearing or whatever you need to do. So that's applicable as well to data that's coming into you. As far as reviewing the case details, you want to make sure that you have the background, the pleadings, where you are with that, what discovery requests have been done, and then whoever is on your team. I know David and others have talked about who is going to be doing the review or who's going to be doing the analysis. If it's just you, you still want to know, what am I looking for? But if it's more than just you, you want to make sure everyone's on the same page. So if you have a data set that's come in and you want to do a project where you're reviewing everything in order to prepare for the key witness, you want to make sure that they understand what they're looking for, and you want to know what you're looking for. So again, that's something to check off. Okay, I got that. As far as confirming the collection, we talked about collection full versus targeted. You want to make sure all the people that you have as key custodians are included, what kind of data you're collecting, and where the data is stored. The review tool is important, making sure that you're familiar with that, because you're not every law firm or attorney is going to use the same review tool for everything. So if you're just doing a one-off discovery and you just need to get something from this one person, you may not need to use a huge review tool like Relativity. You could just be reviewing everything via Outlook and seeing what that metadata is and getting that done. So as long as you can identify how you're going to attack the problem, how you're going to attack the information that you have coming in, then that's one less thing that you have to worry about. Then as far as the analysis protocol, what that usually means is if you have an order that you're working with from the court that you need to do things a certain way, you want to make sure that you're applying that across the board. Or if you have a team of attorneys that you're working with, they should have an analysis protocol. There should be, if one person is working on this custodian, they should have the same information that they're looking for that someone else might be looking at for another custodian. It's really just to make sure that there's uniformity in how you're reviewing everything, what kind of questions to ask, and how to tag things if you're in a review tool. Let's see. And then as far as the production plan, the production plan that I included in my handout really is like an Excel spreadsheet or even a Word spreadsheet where it has little headings at the top, available data, as in what kind of data is there, production endorsements, are we going to do bait stamps or are we going to do hash stamping, are you going to produce this type of data? And if you are, in what production format? A lot of that comes with what you've already agreed with opposing counsel or what the court has already ordered or what you're requesting. The Florida rules and the federal rules require that if you're going to ask for discovery, you have to specify the manner in which you want it. Otherwise, they will send it to you however they want it. So if you just want PDFs with a metadata load file that comes with it or something like that, or if you want images in their original digital format, then you have to specify that in your request. I cannot tell you how many times I've put that in my request and I still get a PDF of a JPEG. And that's not going to work because if I need to know when you took that photograph, that PDF will not have it. So as long as you specify in your request what you're looking for, the court will uphold it because it's required in the rules of civil procedure. Otherwise, whatever you get, as long as in a reasonable, usable format, then they have complied with the rules and you're kind of out of luck unless you want to ask for another request. Well, in your case with the PI stuff, if you should ask for JPEGs. You should, if you're getting a photograph from a phone, it should be a photograph from a phone. It should not be a PDF document. It should not be a printout. You want to know who took it. A lot of the photographs that are taken nowadays on the phone, when your location is on, we know where you are longitudinally and latitudinally. We know exactly where you are when you take that photograph. That is included in the metadata for that photo. And you know, I've had something like that happen before where they took the picture and they said they took it at one point. When I opened it up and looked at the metadata during the deposition, that wasn't them. They got it from someone else and it was taken at another time. So you want to make sure that that information is in there and you specify. You're in control in that way, and then you can also make sure that you include that on your production plan. And finally, on that little spreadsheet, you want to include a reason to produce or not to produce either a certain data set, a certain type of data like emails from this custodian I'm not going to produce for this reason. And it just gives you a framework to follow. But it is just a guideline. I think as long as you have these things in mind when you're working on production, analysis, and review, that section of discovery, then it'll help you to streamline. Again, bottom line, it will also help you to be able to answer to the court and to your client as to what you've done. So that's my presentation. Oh, you have any questions?
I just want to say in follow-up, what we ask for, we work with our vendor and there's certain load files that they request for their program. So I would work with whatever vendor, and then we say in native format. So if it's an Excel, they have to send it to us in the Excel file. If it's a PDF as the original, it would come as a PDF. That way you don't have to know, if you don't know what you're getting, you can't always know what you ask for. So we say
Exactly.
native in DII load file.
Right. And that's important to remember because you are in control of that information. A lot of people don't understand native format though. So if you sit, my shortcut for that is original digital format. Sometimes it's easier for people to understand, yeah, I'm not printing this out. Definitely don't ever ask for Excel spreadsheet in PDF. Yes, ma'am. Okay, very, very good question. And the question was if my last page of my standards for doing discovery has to do with an index. I know what you're talking about, but if you're using an electronic ESI or eDiscovery tool, whatever information is on there in terms of the load file, or which contains the metadata, that's your index. It'll give you the information such as when it was created, that's your date, who authored it, that's the name, who it was sent to, especially in an email, that's who it's going to, and it'll give, and then you can go in when you're doing that review, you can add information about what this document is about and then tag it as to whether or not it's responsive to the first request for production, second request for production, third, or if it's privileged. All of that information can then be converted into either an index, or it could either be converted into a privilege log, which you can then use at a later time. But that replaces the time-consuming process of creating an index of all the documents that are being created in any discovery matter.
Does the software allow you to sort by date and things like that?
Absolutely. All of them do. All of them allow you to do that. And also, based on how it's set up, depending on the vendor, you can pull down anything you want. When you're using relativity, for example, you can set up data sets where you're searching for information that you can pull down and use to bring to an expert hearing or expert deposition, and that's all basically your index for that thing. So I understand what your question is, but once you have a tool like that, you can use it, but there are also other ways that you can coordinate and identify the data so that you can use it in your day-to-day. And that was one of the things that I wanted to do with this standard. Yes?
My question relates to email. I had a recent matter where a small business had to produce about, had in his Outlook box, about 20,000 emails that were sent. And a larger company that he was adverse to in a case was requesting all of his ESI, including his emails. And so my question to you is, what would be the best format to produce the emails in? Two, with that kind of volume, what we ultimately decided to do was convert those emails to PDFs so that we could date stamp them and track them. But if you have another suggestion as to how to do that in a native format, please suggest it. And then third, is there any responsible way to produce those emails without hiring an outside vendor, which probably would have cost $20,000?
Right. Okay. I'm sure that some of the information that you're requesting is included in the next step, which is the production side of this. But I can answer for you now that yes, there is a way for you to produce the emails in native format without having to basically discard the metadata that came with it. And that's basically by producing a PST file of that information, which is a container.
That was the format they were in, but we didn't determine that we could date stamp those and track them.
Right, and essentially what you'd be doing is you'll be pulling out each email and naming them with a hashtag, with a hash value, I should say. That gives it a specific name, which then you can identify just like you would a Bates label. But you would basically be giving them two sets, a copy set with new names and the full PST, which has all of the original data in there. And the thing,
All the time to go through 20,000 emails and have to label each one.
no. The labeling is completely automated, and you can even do that by yourself using some of the really easier tools that the eDiscovery industry has now that you don't have to get a full license for. You can use one of their proprietary things as a one-off kind of deal. But if you have more questions about that, I can definitely talk to you about after. Thank
you. Okay, you're back from your break, and we're into the production. And I'm going to kind of cruise through the rest of this to get you all fed in a minute. How do we actually produce? Chioma just mentioned this, but she talked about what type of format that you want to ask for, and you can look at her handout online to see that. Load files, incidentally, in the middle there, is for older eDiscovery software. Some of it has an actual format that it has to come in. That's a load file. Whoops. This is the production, that screenshot from Cicada that we're going to see this afternoon. And it's a menu. It's a drop-down menu of how you're going to produce your search, what format, what you want to include in it, that type of thing. You're going to want to run some form of quality control checks on the data to make sure that what you're producing is what you actually intend to produce. And make a copy, make your production letter, update your production log. A lot of this software will automatically create, it'll automatically redact, but it'll automatically create your privilege log for you based on what you tag. Now, we talked earlier this morning about defensibility. When you have to defend the search that you've conducted, you're being accused in a case of not having done the search properly, not having collected the data or produced the data, and the question becomes, based on what you've done, can you defend your own search if need be and say, this is what I did and why? What I'm going to do here to get you all fed right now is I'm going to skip forward and then I'm going to bring Dan back, and we'll do, while you're getting the food and stuff, we'll go through some of his slides so you can see how trial graphic works, legal graphic works, actually uses this stuff for you in the production in court. So let me just jump forward a little bit. This is on the website. These are some helpful websites and information for you. This is eDiscovery. Focus, focus, focus. It took a minute. Right, hamburger buns in the hot dog bag. You had one job. So you want to focus on what you're doing, plan your eDiscovery, and then execute that plan. And in eDiscovery, early on in the process, a mistake can be multiplied tremendously later.
Thank goodness for you fine people, because I could never sift through all these things, and nor would I want to. But at some point, when you get down to the important parts of the case, you're going to want to show these things to somebody. You're going to want to take all that complicated information and make it a little bit simpler and something easier to digest. So quickly, I'm just going to go through, these are 4 different technologies, if you will, or techniques that we've used in some things that you might be discovering. This first one is a surveillance video. Dave, you can go ahead and play it. But what it is your run-of-the-mill, I suppose, slip and fall. So a woman walks into the screen here. She comes down to about the middle of the frame. She falls over. Doesn't really necessarily look like much of anything. When you look at the video a little bit closer, and what we were asked to do was, hey, I can't tell if this lady just tripped over her own feet or her heels, or if she just slipped on something. So what we were asked to do was to analyze the video a little bit more and see if we could tell what happened to her, what happened to her foot, or why she fell. So as she comes down to the frame, she would come through one time, and then we'd show her foot in greater detail, just focused in down on the foot and seeing what happens to her. When you look at that, you do see that her foot actually slips, and then her ankle rolls over after her foot slips, and she falls. Doesn't necessarily mean there was water on the floor, but if there's testimony or something else that says that there is, it's much more compelling than just watching the woman fall down in a store. You can go to the next slide, David. This one is an interactive PDF. What you would see is you're able to actually send this out to somebody, and they can open up with Adobe Reader or any kind of PDF reader software. They can mouse over each one of these. This was an electrocution case. A gentleman was trimming a tree here and was electrocuted. As you hover over each of these, the site of the incident, witness 1, 2, 3, expert opinions, the PDF will actually light up. So it'll tell you, hey, this is the site, this is, this house. Witness 1 was in this house, and you see a viewpoint from witness 1's backyard. You see what they were seeing, witnessing this incident. Witness 2 would be over here. Witness 3 would be back here. The expert opinions would be documents. You'd actually see the OSHA report and those documents come up. Damages would show you pictures of him and his family. An autopsy report would show you cause of death. And all of those things are contained in one document that you can send out to somebody and say, here, look, this is what we have. This is what I want you to pay attention to. And they can run it themselves. It's a very dynamic, very interesting way to send something out to somebody. Same thing here. We talked about cell phone dumps. This, when it plays, is you'll see the text messages come in with their face. I mean, something bad is going on. He tells Jane Doe, don't let anyone see you leave your house. Bring black garbage bags. I mean, it sounds really bad. This is not something that you'd want to, not the text message that you want to get. But you can animate those things so that when you play it back for somebody, you're actually seeing it come in, and you can go step by step. At 7 o'clock, he says this. At 8 o'clock, she says that. And it's not just a screenshot of a cell phone. This last one is actually contained in a PowerPoint. And PowerPoint is a very powerful tool. You can really do a lot of neat things with the more modern versions of PowerPoint. So this is a timeline from a personal injury case. The focus being, here's where they got injured. Before that, they really didn't see doctors all that much. We're going back to 1999. So from the left to here is 13 years of this person's medical history. And you see there's 20 flags maybe, 20 doctor visits. This is the 4 years after they got injured. And you see how many times they've been to the doctor and had medical procedures. And David, if you just pick one of those active flags, each one of those you can click on if you want to know what that visit was. You can see the document from that visit. You can see a call out with the pertinent information from that visit, etc. So there are a lot of really great tools and things that you can utilize to make all this information make sense and mean something to the important people that need to understand it in a case. Unfortunately, I do have to go back to the office. I know we have the judges here. I don't think we want to take time for questions or anything like that. But if you need to contact us, it looks like you all have our brochures. Our phone number is there. I have my cards on the table. Our website is very simple. It's legalgraphicworks.com. You can get a hold of us if you need to. But if there's anything that you want to talk specifically about, we'd be happy to answer any of your questions. And we do answer our phone 24/7. So if it's Saturday night and you need some edits for trial on Monday, call us. All right. Thank you guys very much.